Good morning, everyone. My name is Liz Clark Reinhardt, and with me is Mary Gardner. We'd like to welcome you to our webinar, When It's All Over But the Shouting, How to Identify and Avoid Ethical Pitfalls During Settlement Negotiations. Thank you so much for joining us. Just a little housekeeping to begin. We are accepting questions. Please send them as they come to you. We will try and answer all of them. Also, if you encounter any difficulties or need to reach out, we do have someone monitoring. And so thank you so much for your patience. I know we're coming to you live from our homes. I imagine many of you are listening in on your homes. And it's nice to be able to have this chat this morning. So let's get started. So we are offering this for CLE Credit. I won't read through everything, but again, this is something that if you would like credit for this presentation, it is available for you. And actually, one of the downfalls, unfortunately, that I'm not in the same room as Mary is that I can't just ask her to speak with my hand. So Mary, would you like to identify yourself, please?
Hi, everyone. I'm Mary Gardner. I'm an associate in Venables Advertising Law Group, and along with Liz, we both do a lot of advertising litigation defense, class action defense, and we're very excited to talk to you today about our thoughts about how to proceed in settlement in a way that doesn't run afoul of your ethical obligations.
Thanks so much, Mary. So first and foremost, why settle? There are many reasons. Obviously, winning is very exciting. I love to win. I love to go to court. I love to go to hearings. But there's always a risk. And the risk is losing, which no one likes to do. And losing can take many forms. So settlement reduces some of that risk. It puts the client in control of what happens as opposed to maybe putting the resolution in the hands of a judge or a jury. And it can also just cut a lot of costs. I have a quote right here from a New York Times article about, on average, getting it wrong costs plaintiffs about $43,000. The total could be even more. And then for defendants, it could be $1.1 million. So there is a lot of risk and expense that is saved from settling. So how does that work into our ethics and our ethical responsibilities as attorneys? When in doubt, your touchstone is always going to be that you represent your client and your client's interests come first. There are going to be times when your client is going to be interested in a settlement that perhaps you as an attorney, don't think is the right choice. Your job is to advise them on their goals. You can certainly tell them why you don't think it's the right choice, but ultimately it's the client that makes that decision. So there are, sorry, Liz. No, please go ahead, I know.
Pardon us as we are the trailblazers of learning how to not interrupt each other in webinars today. So you may be thinking, what are the actual ethical obligations that are going to really come into play and be the primary concerns that you have during this process? And I think Liz touched on one of the most important ones, and that's your duty to put your client's interests first. But the others are certainly, acting competently, diligent representation and responsiveness to your clients. And, one of the things we're going to talk about later is your duty of fair dealing, your obligations to adverse parties, adverse counsel, and the court in settlement negotiations. So those are kind of the themes that will be running through everything we talk about today, and in what we hope you'll be thinking about as you hear us and think about questions and hypothetical scenarios that you'd like us to run through.
Excellent point, Mary. Thank you. So when to settle? Again, settlement is ultimately a business decision as much as it is a legal strategy, primarily because of the economics. Can you settle right away? That may be the cheapest option. Now, right away, I think we can all think about reasons why we might not want to settle right away. Oftentimes we get a case in front of us, we think this is nonsense, I want to fight this, I'm annoyed, and that may be the right way to go, but we have to balance that against the potential costs, legal fees, again, what happens if we lose. You can also wait till after motions practice. That's a very popular option. Try that motion to dismiss. See what happens. It lets you take the temperature of the court. It lets you maybe whittle away some of the claims. So for example, if you're presented with a complaint that has 12 counts in it, that's pretty aggressive, and it's probably unlikely that all of those claims are going to survive. So you'd be in a stronger settlement position if you file the motion to dismiss and the court calls some of those weaker claims. Another option is after discovery. Now that is a risk. It's a risk, one, because discovery is very expensive, and so you're already investing time and money in a case that you'd like to settle. It also statistically means it's less likely to settle. Once parties have gone through the discovery and the motions practice therein, they just seem like they've got that mindset of they're entrenched, they're ready to go to trial. So it's a high risk. You can also try prior to trial, those kind of last minute, courthouse hallway deals. They're dramatic, but it is something that you should never let go of, the idea that just because we've prepped for trial doesn't mean settlement isn't still the right option here. And then every once in a while, I come across a situation where parties want to settle after trial, where one party is ready to go onto an appeal. Everybody knows that that's going to be an additional cost, and there's a way for the parties to come together. So my rule of thumb is always that the best time to settle is when the settlement can be reached, and that's going to depend on a variety of factors. Mary, did you have anything to add?
Yeah, so I think as well as kind of assessing when is the right time to settle, I think a lot of lawyers in the room are, potentially wondering about, when should you first talk to your client about the possibility of settlement? Liz, what are your thoughts about the timing of those discussions and how frequently they should occur?
So I think best case scenario is that you talk to the client about settlement the minute the complaint comes in, the minute you even hear about a complaint. It should pervade basically every discussion. Now, of course, you got to take the temperature of the room. And we talk about this a little bit more in the presentation. When, someone is angry, when someone feels that they're being wronged, that they're being, maligned in public documents, they're not going to be open to settlement right at that moment. But it's still worth mentioning. It's worth putting that sort of seed, planting that seed that there might be a way to solve this that is going to save a lot of time and a lot of money and may also reduce the amount of public information that gets out there. Again, these are all factors we'll talk about later. But really, I can think of a time to talk about settlement based on just about every topic I've ever talked about with a client. It should be running through the conversation at all times.
Right, and I think with respect to your ethical obligations, that runs to your obligation to keep your clients informed and allow them to make decisions in their best interest. And so if you're talking about the possibility of settlement early and often, you're giving your client, you're helping your client develop some reasonable expectations for what this could ultimately look like. You're keeping them informed as those expectations should change. And ultimately, we've all been in situations, unfortunately, where the case ultimately settles for far less than the legal fees expended to defend it. And it's important to ensure that, you don't have any buyer's remorse and that people kind of understand the trade-offs there. The other thing I'm sure, I know we have a lot of in-house counsel on the line today. Another issue that I think rises a lot, especially with general counsel and people with large amounts of responsibility, is how much authority can a client grant to an attorney to settle? Can a lawyer accept authority to just go forth and settle as long as it's less than $1 million? What can that authority look like? Are there any constraints on the amount of authority a lawyer should accept? What does that world look like, and how can you advise in-house counsel regarding, exactly how far they can cede settlement authority?
No, that's a great question because I think it does come up a lot, and often in the heat of settlement negotiations or in the fast pace of settlement negotiations, it's very easy for people to let this type of topic kind of slip their mind. The short answer is that attorneys should never accept blanket authority for any settlement. The best practice is always to run any settlement terms by the client. And that could mean for in-house counsel, running it through the business department as well. I mean, that sort of goes more towards the structure of authority within the client. But certainly for outside counsel, working with in-house counsel, I would recommend running these terms by your client at all times. So you're going to want to just say no to agreements with your client that would grant irrevocable authority to settle. Just say no to agreements with clients that would authorize you to withdraw if the client refuses to agree for your recommendation. Again, going back to our touchstone topics, the client's interests come first. Just say no to agreements with clients that would relieve you of any ethical obligations. Again, that in and of itself is an ethical violation. So really keeping your client informed, letting them take the driver's seat in settlement, and you are the advisor, that's going to be your safest bet and the one that keeps you out of these sort of ethical murky areas.
Now, and Liz and I aren't saying that, the client has to be, in the weeds on settlement negotiations. It is possible to give certain authority parameters to your lawyer that would not run afoul of ethical obligations. Something I think is always a good option when you're talking to your lawyer about settlement is kind of mapping out what your priorities are with respect to a settlement. Is it really important that the monetary figure not exceed a certain level, or perhaps it's more important to have certain certain non-monetary elements such as injunctive relief or declaratory options to get those off the table. And I do think those kind of discussions can really help inform your lawyer so that while they're handling this for you, they can take some of this responsibility off of your plate by really understanding what your most important priorities are and trying to craft a settlement option that they can come and present to you that will be more aligned with what you need.
Excellent. That's a great point, Mary. And I think it underscores the idea that this type of communication, the earlier it starts and the more, developed the settlement communications are between the client and the attorney, the more that the attorney can go and negotiate what will ultimately be an acceptable settlement and take some of that off the client's plate. Exactly. So one thing I do want to bring up, since we're talking about when to settle, is the idea of a good faith settlement negotiation. And again, this will be something else that will come up later, but you want to go into settlement negotiations with the intent that a settlement is actually possible. It would be considered, and probably would be considered bad faith to initiate settlement discussions where either the client or the attorney, which is a whole other ethical dilemma, has no intention of actually settling. It could be seen as a delay tactic. It could be seen as a way to simply just obtain information. So I would certainly strongly advise you to avoid any sort of tactical settlement discussions that are made without the actual intent to achieve a settlement. Now, that doesn't mean you can be optimistic. You have to be optimistic about settlement. I've certainly, and I'm sure Mary has as well, been in settlement discussions where the parties do not have a lot of optimism that settlement can actually be reached, but any sort of movement is still progress. What I'm talking about is a situation where the attorney walks in thinking, I'm not even here to really settle. I'm using this as sort of a ruse to get information. That is certainly something that is to be avoided. And if the client suggests it, that requires a very serious conversation about the attorney's ethical obligations in that situation.
Right, and I will say, just as an anecdotal, last year I was reading a Law 360 article, and a party went to a court-ordered mediation without an authorized representative with settlement authority, and the court ordered sanctions against the lawyer in that case for essentially coming to mediation without the proper authority, and thus kind of exhibiting some bad faith. So this can really have real world repercussions for both clients and the attorneys. And so it's important to make sure that you're prepared and open when you attend settlement negotiations, especially if court ordered.
Certainly, yes. Courts take this very seriously. I know in the District of Maryland, where I do most of my practice, settlement discussion happens, with the initial scheduling order. And it's expected to be taken seriously by the parties because the courts do invest a lot of time in it. So that's an excellent point.
So Liz, why don't we actually transition a little bit to talking about the meat and bones of negotiation?
Okay, that's an excellent point. Let's move on. So how to settle. So I start with one of my favorite Larry David quotes. I'm assuming it can be attributed to him. A good compromise is when both parties are dissatisfied. So this is true, definitely true. A lot of settlements, people are going to feel dissatisfied. On the other hand, as with sort of the risk-benefit analysis and the cost-benefit analysis, the idea for settlement is to come away feeling more satisfied than dissatisfied. There are a lot of positives to settlements. You get closure, you get finality, you get certainty, but you have to walk in prepared that you may not get everything that you want. So with that in mind, let's talk about how to actually settle. So who should attend? Mary hinted at this, but you need someone with authority to actually bind the party. Now, you also probably want counsel to be there. This is especially true if there's an open litigation matter. If you're looking to, discuss this with counsel and keep this within attorney-client privilege, keep it within work product protection. The more discussions you want to have about the settlement that you want to be protected internally, you don't want to have those with non-attorneys. There's always a risk that can be discoverable. And so to the extent you want to bring your counsel in and you have the ability to bring counsel in early on those discussions, you should definitely do that. Now, there are situations where a business-to-business discussion might be more effective. It might be more fruitful. Again, I would still run that by counsel, but it's not something I would totally rule out. I don't know, Mary, if you have thoughts about that.
No, I agree with you on that. It's important to have your counsel involved. They're there to help advise you.
Yeah. And then court versus private mediation. So most courts that I deal with will have their own sort of mediation system. So for example, again, in the District of Maryland, we have a wonderful magistrate judge bench. And so you'll have magistrate judges who will be assigned for discovery. They can also handle the entirety of the litigation. And then you'll have separate magistrate judge that would be assigned to handle mediation. And as I mentioned, those things are scheduled. They like to schedule them basically with the initial scheduling order. So you'd be looking about 3 to 6 months out. Oftentimes parties will request to wait until after discovery, which, as we discussed, has pluses and minuses. The benefit of the court-ordered mediation is definitely a cost. It is usually much more cost-effective than the private mediation. And you also have a little bit of gravitas. You're in the courthouse, you're with the judge or a judge that perhaps the parties practice in front of. It just, in my mind, tends to keep everyone on their best behavior. Private mediation, I will say in my experience, and Mary, please feel free to chime in, the private mediators, because they are being compensated, tend to give a little bit more service in my mind. Like they reach out a little bit more aggressively. They are somewhat more invested in sort of closing the settlement. Again, this is just a total generalization, and you'll find, each individual mediator and each individual judge may have a different approach. But And then
and I agree
out of the courthouse.
Yeah, and I agree. I agree with Liz about the bonuses of using a private party to mediate. Again, it's a generalization, so it's really important to do your due diligence and your research on any private mediator to get a sense from colleagues about how successful this person is in mediating, understanding if they have any biases. If you're in a really specialized area, trying to find somebody that even if they don't have experience in your area, at least seems to have other kind of complex mediation experience to kind of grasp the issues. I do think one of the cons of private mediation can be that, if you know you're right and the other side's case is really weak, they will sometimes beat up on both parties and try and find a middle ground that you're not comfortable with. So, it's important to have a discussion before the private mediation about, again, what your goals are, what your priorities are, what you're not willing to compromise on, so that when you go in, you can keep all of that picture in mind during what can be a very long and exhausting day. But again, client interest first. Just make sure that you're following the parameters of what your client has told you is important and what they will and won't compromise on.
Yeah, I think that communication is certainly just key. And that's similarly the case if in the course of your discussions and your preparations for the mediation, whether court or private, it becomes apparent that perhaps the client and the attorney do not agree on the strategy, or the attorney feels as though the client's strategy may be touching upon or even violating the attorney's ethical obligations. This is why the preparation is so important and the communication is so important, so that those types of issues can be resolved prior to going to the mediation, if for no other reason than in private mediation, you're paying money to be there. So you want to be as prepared and as in sync as a team as you can be before you start. And as part of that,
and it is important.
Go ahead, Mary.
It's important to understand if you're the lawyer and you don't agree with your client's strategy, or you think that your client's asking you to do something that's unethical. What are your rights there? The model rules provide a little bit of guidance on that, in saying that as a lawyer with ethical obligations, you have to ensure that you retain the freedom to refuse to take a step that would violate those obligations, and that in that situation, you can you're not required to perform acts that you think would violate those. And in certain circumstances, you may even withdraw from the representation should the client, refuse to heed your advice in that situation. Liz, can you talk a little bit about when it's appropriate to withdraw from representation when the client and attorney have fundamental disagreement about settlement conduct?
Yeah. So, again, this all goes back to communication with the client. And discussing these things in a frank and honest manner. And I understand that can oftentimes, if not always, be uncomfortable. But if it gets to a point where the client is in fact insisting on an objective that the lawyer, upon consideration, has concluded is repugnant or imprudent, and has communicated that to the client, obviously, the lawyer can't just, decide one morning in the shower that this is it and they're done. But if that has been communicated and the client is insistent, then at that point the representation simply can't continue. It's no longer in the best interest of the client. It's no longer something that the attorney can do and maintain her ethical obligations. And so withdrawal is really the only option at that point. Additionally, I think one of the more sensitive things we need to talk about is that oftentimes our clients are faced with sort of bet the company situations or settlements in which there is going to be a sizable financial burden, and that's still the best of the options that are facing the client. That can lend itself to difficult conversations about attorney's fees. And that combined with perhaps other situations that are complicating the representation or making the representation difficult for the attorney, create an unreasonable financial burden on the lawyer. Again, that's a very sensitive discussion. It's one that needs to happen as soon as possible, as soon as it is the attorney identifies that this may be an issue, because that would also lend itself to a withdrawal of the attorney. Basically, to put it short, a situation in which the attorney is not going to be able to be compensated for their work for any number of reasons. Okay, so just to wrap up this slide, one of the preparations typically you would do is just sort of a brief statement. I actually find these to be very helpful, even if you don't think that settlement is moving forward or the settlement will be, you know, consummated at the event in which you're preparing the brief, because it really helps to distill down the case and its strengths and weaknesses. And to the extent you haven't been discussing with the client the weaknesses of the case, this puts them, you know, front and center and really requires that kind of discussion. And that's why the court and the mediators like to do it. It's not just that they use it, but it also just puts everybody in the framework of what do I have here for real? Because oftentimes I think I've heard, you know, mediators and judges who mediate speak, and everybody thinks their case is the winner. Everybody thinks they've got a multi-million-dollar verdict that's just waiting for them at the end of the rainbow, but that's rarely actually what's happening. And so the brief kind of puts that all into words that people can't deny. So some ethical pitfalls. Adverse counsel. So I think, and again, Mary, please feel free to chime in if this isn't your experience or if it is. One of the interesting things I come across a lot in my settlement discussions are attempts to restrain practice for adverse counsel. And those can take unusual forms. And oftentimes when we're brainstorming settlement terms with the client or when the client comes with their ideas for settlement, you know, we deal with frequent litigants often, and we deal with sometimes similar attorneys. And so eventually someone comes to the conclusion, hey, why don't we make it, you know, we're making an agreement anyway. Why don't we come up with an agreement so that this person has to stop suing us, or that this person can't just go find another plaintiff and bring this exact same case? And the problem with that is that restraints on practice are, I would say, blanket, never allowed. Settlement
big
agreements
ethical no-no.
Yeah, it's a huge unethical no. It sounds so attractive. I will admit it. You know, like you're sort of, you're particularly when you're dealing with the same counsel over and over and over again, and you're going into the minutia of these settlement agreements, and you feel like you can just you know, tick some boxes, and we're wheeling and dealing, and this, you know, let's just negotiate here. No, this is a screeching halt, full stop. It cannot be done. And the problem is that it takes multiple forms. So certainly you cannot put in a settlement agreement, Liz Reinhart is not allowed to sue me ever again, because that's a restraint on my practice. But you also can't put in anything that would basically lead to that conclusion. And one of the more creative ways I've seen this done is to hire the attorney as a legal consultant, and thereby they are conflicted out. Yes. And again, this is not to ascribe improper motives. This is a really creative, great idea. In the sense that if you're a company and we always
encourage creativity.
Yes. Oh, totally. If you're a company and you see that you're being sued by, you know, on a particular issue, and you see that there's a particular attorney that is an expert in these matters, of course you want to bring them in and say, hey, what am I doing wrong? How can I avoid you? The problem is that is basically going to mean they're conflicted out. And so it's a very difficult, that would be a very difficult needle to thread in terms of bringing that on. Basically, they would have, I mean, Mary, can you think of a way that could even be done? I mean, maybe if they were giving up their private practice, I'm not sure. Honestly.
Yeah, I think
I don't know
if you saw a I think if you had a retiring lawyer who, I think about, the TCPA world is a good place where we see a lot of the same plaintiffs bar over and over again coming to our clients. And I think if someone was retiring, especially, like they do have a specialization there and they can be really helpful to you in kind of helping you assess, but you would need to know that they don't want to practice again so that you're not restraining their practice. And that would probably require a long conversation with them and written documentation of it so that it wouldn't come back to bite you. And I mean, there's always going to be a risk even in that situation.
No, that's a very good point. It's a very risky situation, and one would often wonder whether this is the only possible person that could consult. And I think that's
Exactly.
Another issue is that, the ethics boards, the people that look at these types of things are going to look a little sideways at this type of arrangement. So, and then candor to the court, obviously that is a universal ethical obligation. Certainly you don't want to mislead the court about your settlement negotiations. You don't want to mislead the mediation court about your intentions, about your goals. And then also conflicts with multiple parties and aggregate settlements. This can become very tricky. There is a possibility if you're representing 2 or more clients in a certain case where your representation of one client would limit your ability to fully advocate for the settlement of the other client. This is particularly true if accepting a certain settlement agreement would require an action based from one client, would require an action for the other client. Basically, I mean, I think to me it seems apparent, but just to kind of spell it out, you can't pit your clients against each other. You have to be able to fully represent each client and their own individual interests. And so, and
I think just to clarify, certain conflicts can be waived when you're representing multiple parties. The example Liz just raised, that's not a waivable conflict. There's really not a world in which you can provide enough information to both clients and received informed consent on that type of situation.
Exactly. So that's the type of thing you're going to want to keep clients informed about.
And it's important to continually reassess when you're representing multiple parties in an action. It's important as a lawyer to continually reassess the existence of a conflict in the relationship. Because there is just inherent risk in representing multiple parties, and as litigation evolves, as discovery proceeds, it may come to your attention that there's a brewing conflict, and it's important to keep your clients updated on that so you can make sure that you bring in different representation should that conflict actually come to a head. And obviously the best way to do this is to make sure you're talking about potential conflicts right up front. But yes, keep clients informed, continually reassess the potentiality for conflict, and seek consent from your clients where you need it. Liz, before we move on, I wanted to circle back up. We are advertising attorneys, so I want to talk a little bit about restraint on advertising. We see so routinely that provisions in the settlement remain confidential. Are these unlawful restraints on advertising? Or is this ethically okay? Is there anything that people should be cognizant of when they're entering into including such confidentiality provisions?
So that's probably a whole other webinar in it of itself. So generally you can include confidentiality agreements as long as they don't restrain an attorney's right to practice. And certainly that would vary from jurisdiction to jurisdiction. So, for example, Virginia and Delaware place restrictions on confidentiality provisions. Other jurisdictions may not. But generally, you can I would basically look at every jurisdiction that you're planning, that you think that may be implicated by this. But I would certainly try and still include the terms, the confidentiality terms. They're beneficial. But you're not going to be able to totally silence opposing counsel from talking about, let's say, their track record or the fact that they settled the case. That will most likely not be permissible. So what else can't we talk about? So that's a very good segue.
Yeah, what can you, what else can't you say?
I know. I really tried to make this not a lesson and a lecture on things you're not allowed to say, but unfortunately that does tend to be what happens. So anyone that's done negotiation and talked about ethics in negotiation is going to be familiar with the concept of puffery. Or actually, since we are advertising attorneys, puffery comes up substantively as well in what you're allowed to say in advertising. So you're not allowed to be misleading as to facts. So you're not allowed to lie about the facts. You're not allowed to conceal material facts. You are allowed to embellish on your opinion. You're allowed to be more confident in your case than perhaps you really feel that you are. Because that is an opinion.
Liz, can you give an example? Can you?
Oh, let's see.
Can you give an example? Like, what's something that would clearly fall on the puffed up opinion side of the line?
I think that a jury is going to find my client very persuasive. That's an opinion, and I think or you can say, oh, go ahead.
Yeah, no, I think that's a great example. What would you consider? Let's do I'm sorry, I'm putting you on the spot, and this is not something we've talked about. Let's say you're the defendant in a med mal suit. What's a material fact that has to be appropriately stated and disclosed in negotiations?
Oh wow, there are so many. I would think any factual information about the record, certainly, the medical record or something that's been discovered, you're going to have to put your ugly facts on the table. You can't materially hide them any more than you could hide them in discovery. So, if, for example, there's evidence in the record that somebody signed something and it turned out that they didn't really sign that, you're not going to be allowed to hide that for settlement negotiations any more than you can hide it for actual discovery. And you certainly can't walk into a settlement agreement and say, like in my example, well, I have Nurse Roberts' signature on this form, and so therefore we know that you have no case, if you know that that's not her signature. That would be my off-the-cuff example. I'll probably think of a better one.
I like it. So Liz, the other thing you mentioned was, there's two sides of this coin. You can't misrepresent material facts during negotiation, but you also said you can't omit material facts. How do you draw the line between protecting and upholding your ethical duty of confidentiality and the need and the ethical requirement to disclose? To me, those seem like ethical rules where we're going to find conflict at times.
I agree. I think there is going to be conflict at times. I think, to me, the omission and the omission requirement goes hand in hand with the implication. Like, what is the implication of what I'm saying? What's the implication of what I'm not saying? Is that misleading to my opponent? And again, I go back to discovery. What would I have to tell them if we were engaging in civil discovery? If I'm implying something is true that I know is not, for a fact, then I think that's getting close to an ethical line that I wouldn't want to rely on. I would want to be honest on that, or I would want to think of a strategy where I wouldn't have to go that close, basically.
Exactly. And I think when you're weighing confidentiality versus disclosure, it's a good thing to remember that you you're running afoul of your ethical obligation to disclose if the material fact you're not disclosing could amount to assisting fraud or assisting criminal conduct. You know, those kind of like real outliers. But further than that, if you're dealing with confidential information that your client doesn't want to disclose, you know, the model rules, the ABA model rules do say that confidentiality should generally trump disclosure obligation. There are some exceptions to that. I would say probably the biggest one is if your client dies in the middle of settlement negotiation. Obviously, that's something you got to disclose, even if, you know, somebody wanted you to maintain confidentiality on that. And I know that's an extreme example, but just to kind of help you inform your priorities regarding confidentiality and disclosure and settlement. Just kind of keep that order of priorities in mind.
No, that's a good point. And it is. That's one of the toughest things I think we all deal with is, you know, what becomes, and knowing what becomes material, what needs to be disclosed. So the other thing we should definitely talk about, again, because it's been sort of weaving through our entire discussion, is what happens if during the course of settlement negotiations, the client asks you to do something that is unethical or even illegal? Again, communication. You need to consult with the client. You need to inform them as to your conclusion that this is either unethical or illegal, inform them as to the type of actions that would need to be taken, meaning that you could no longer represent them. And then if you really have reached an impasse, then you're going to need to probably step down and withdraw. And that sometimes is enough for the client to think, well, wait, maybe I need to rethink my position. But if it's not, at the end of the day, the ethical obligation is going to have to trump that. And hopefully, again, with proper communication and preparation, it won't get to that. But I don't think it's, you know, it's important to keep in mind how tense settlement negotiations can be. There's a lot on the line, and people who may normally act rationally get very emotional, and that's something to always be considering. And again, that's why the communication beforehand is very important, that building of the rapport and the relationship with the client, so that when you go into these negotiations, if tempers flare, if emotions are high, the client feels like she can trust you, and that, you know, she can have these frank conversations with you, and have these disagreements and give proper advice. I can't underscore that enough. I think sometimes we forget, and we think very logically and very legally focused, but a lot of settlement is about feelings and emotions and irrational decisions, unfortunately.
Yeah, and the best we can do in some of those situations as advisors to our clients is what Liz said. Create the trust, understand the risks, understand the positives and negatives, and have that kind of open dialogue from the beginning of the case so that the client has reasonable expectations going into settlement. And that can really, those expectations, you know, creating those expectations early and reinforcing them over the course of the litigation can be a vital assistance as you're coming to the home stretch on a negotiation.
It's worth the investment. It's worth the preliminary investment to get that relationship built. Definitely, I totally agree. So class settlements are kind of their own complicated settlement ethics issue, and it's something that Mary and I deal with a lot. They're procedurally complicated, basically, because the Federal Rule of Civil Procedure 23, which is the class action rule, actually outlines some of the requirements for settlements. Now, this is particularly true when you have a already certified class. So circling back to very early on in the presentation when we talked about when to settle, if you're facing a class action, you should settle before the class is certified. That will make things a lot easier if you can do that. So that's one of the reasons to start those settlement discussions right away. Class actions are a particular breed where when you settle is very, very important, because once that class is certified, one, the plaintiffs are going to feel very emboldened. It's a big win, unfortunately, for defense when the class is certified. And so whether true or not, I mean, there's obviously substantive arguments as to how much meaning you should ascribe to that. But So definitely, if you've got a class action, trying to settle with the individual plaintiff or the representative plaintiff first is the best course of action. Once the class has been certified, there's a lot more court oversight that has to happen, and that's because typically when you are settling the class action after class is certified, you're settling for the class, and the class is not there. And so the plaintiffs who are representing the class, the court just wants to make sure that whatever settlement is reached represents the best interests of not only the representative plaintiffs, but also the class. And so that requires sort of, what you would think it would require. You're going to inform the court. If the settlement will bind the class, which I would certainly hope that it would, then you're going to need approval of the court. And then you're going to need to notice to the class, send the notice to the class. And the way that notice is done will vary, and that's part of the settlement negotiation for the class action is whether you do mailers or whether you do online or whether there's another method, and that's usually a subject of heated debate in the settlement negotiations. And then once the class is given notice, there's an opportunity for class members to object. And occasionally this will happen in an actual hearing. The court will hold a hearing. I won't even say occasionally, often. This will happen in the hearing. And I have dealt with cases where there are objectors that come up. There are, in fact, individuals who, as a point of, I'm not sure what the word would be, they have sort of a moral calling to object to certain settlements. And I've noted one of them here, disclosure-only settlements. Oftentimes in, let's say, sort of securities actions, there will be class actions that are brought by investors on the idea that a particular securities filing omitted a crucial detail or was misleading by omitting something. And so this settlement will really just involve disclosing what was arguably omitted, and then attorney's fees. And there is a whole breed of people, and including this the In Re Trulia case, that finds those to be questionable settlements. And so there are objectors that will show up solely on that basis alone. And so the hearing will go through, and it actually creates something of an interesting dynamic, because at this point, defense and plaintiffs are not on the same side, but they certainly have interests that are beginning to align, because both they've agreed to this settlement and they want the settlement to be consummated, and then there's objectors. And so you sort of have a kind of us versus them that forms between the objector and the parties. But that can create ethical dilemmas, because you're still obligated to represent your client and your client's best interest. So navigating that, it just has to be considered very carefully. And then once the court has heard all of this and heard the objectors, the court will rule as to whether the settlement is appropriate and whether it will be approved. Mary, did you want to add anything to that? I realize I just spoke for way too long.
I think one of the things we talked about earlier is, gauging potential conflicts when you represent multiple parties. And, that's certainly, there are different considerations that come into play in classes. Liz and I are on the defense side of this, but one thing that, people who are defending against classes should keep in mind is that, is looking at when there are subclasses. So if you have multiple state, two different states, a California class and a Virginia class, if you start to suspect that there are opposing interests between those subclasses, that is a conflict for the class attorney. And that is something you should be mindful of, and defense counsel should be mindful of and keeping track of, because you may be able to attack the adequacy of class counsel based on that kind of conflict and the failure to address it. So there are some practice points you can pick up sometimes from ethical obligations of another party.
That's an excellent point. And then as a final note on this slide, I talk about the cypre and where the money goes, basically, if the class doesn't get it. That creates an ethical question. There are certain organizations that rely upon these types of settlement, this influx of money from settlements that are not collected by class members, as part of their organizational funding, and they're nonprofits, but at the same time, they are there, and that can create a tension if you're representing plaintiffs, and negotiating the notice provisions. Like the objective should always be to give notice to the class, that there is an ethical obligation that the class receive notice and that the class receive adequate instructions and as the least amount of burden possible in terms of collecting the settlement to which they are entitled. And so whether it's going to be a lump sum given to a nonprofit or whether it's going to revert back to the defendant, those can create some incentives, maybe some negative incentives or some incentives that need to be addressed to make sure that the ultimate goal of getting the class their settlement is effectuated. So pre-certification, if you're taking my advice and trying to settle before certification, the main thing that comes up in this situation is the idea of picking off the plaintiffs. And there's nothing particularly wrong with that. If you can create a settlement with the plaintiff before the class is certified, by all means, go ahead and do it. The problem exists when, or the problem is created when parties try and force a settlement with the plaintiff. So one of the most recent cases, the Campbell Ewell Company versus Gomez, happened to be a TCPA case, which is a law that Mary and I know all too well. But the overall holding was that you can't force plaintiffs to accept a settlement by giving them the full relief that they could receive. So without going into like the details and the kind of constitutional standing arguments that the court goes into, although I would love to at another time, the idea is that just because you have offered the plaintiff what you believe to be full relief that they are entitled to does not mean that there's no longer a case or controversy, does not mean that the case has been mooted. There are other reasons that class action plaintiffs pursue their cases. And once you've made that offer of settlement, if the plaintiff has rejected it, then the offer is gone. Contracts 101, you make the offer. If it's rejected, then the offer is no longer in existence. And so the case can continue. So that's an important note. I think another creative solution that often comes up is something similar to this, that, we'll just send the plaintiff a check and therefore, we've given them full relief. They can't pursue their case. And basically the Supreme Court has said that that's not going to fly.
But Liz, there are ways that you can use these offers, generally kind of Rule 68 offers of proof to your advantage, right?
Exactly, yes. And one of the best examples is here on the slide. Although you can't force settlement, you can bring up the fact that you offered the plaintiff full relief or that you offered a reasonable settlement. And so one of the things that happened in this case, Franco v. Allied Interstate, is that the court found that there was an adequacy issue with the plaintiff, the class representative, because the plaintiff had rejected without explanation a Rule 68 offer of judgment. And so I've included one of the more notable quotes from the opinion. There are certainly reasons why, as the Supreme Court has stated, why a plaintiff would want to continue, but there has to be an explanation. The plaintiff has to explain why they would reject that type of offer of settlement and why it's in the best interest, why they can still represent the class given this decision. Underscoring all of this, whether said or implied, is a general suspicion as to attorney's fees and class actions. The courts are looking more critically at these types of settlements when they seem to bring more money into the attorney's pockets than into the class members. And so that's, again, something we want to think about, not just for ethical obligations, but also in terms of when the court has to approve the settlement, the court's general oversight of the case. So with all that in mind, I don't want to downplay, and in fact, I want to encourage creativity in settlements. There's so many options outside of the courts that can be used to bring parties together and to resolve these conflicts in a way where people walk away feeling like they've been heard and they have been, at least, if they didn't get everything they wanted, they got what they needed, to sort of paraphrase the Rolling Stones. And so, how to start that creativity, that creative process, because I know sometimes we really get into the nitty-gritty and the rules, and it's hard to kind of to break ourselves out of that. So what are the motivations of opposing counsel? Don't discount that. If opposing counsel has either a financial motivation or even a sort of, they just feel this is the right thing to do, you have to think about that, and don't discount it just because you disagree, because that's going to be a determinative factor in how they negotiate the settlement, how they advise their client. What are the motivations of the plaintiff? Same thing. Is the plaintiff motivated solely by financial considerations, or is there some sort of moral imperative that the plaintiff is feeling? And then what are the pressure points? Are there financial pressure points? Are there privacy pressure points? I mean, obviously, I don't want anyone to go out and start spreading secrets publicly as a way to pressure settlements, but at the same time, there is a benefit to keeping these types of disputes as private as possible, and that should be considered in the discussion. And then what other external factors and resources could be employed? Don't send people to intimidate, the other side, but at the same time, if there are relationships that can be developed, if there are other, let's say regulatory or legislative goals where the parties could either work together or whether there could be compromises, I would just say don't take anything off the table. As long as it's ethical, think about it, run it through some discussions with counsel or with your client, and see what you can come up with. Mary, did you have anything to add to that?
No, I think you've covered it nicely. I know we're running up to the end of our time today. Yes, I'm not surprised. Liz and I are actually very passionate about our litigation practices, and so I think we could probably talk all day about our theories and thoughts about the best way to move forward with these kind of topics. But I do think it's important for us to touch on Federal Rule of Evidence 408 before we wrap up. As most of the lawyers on the phone know, Federal Rule of Evidence 408 provides kind of a protection for the statements that the parties exchange during settlement negotiations, and prohibits any party from using that evidence to either prove or disprove a disputed claim or a disputed fact. But there are exceptions for how you can use that. Liz, do you have any practice points for the best ways to create admissible uses for settlement, statements made in settlement?
I think the adequacy one is definitely the one I go to the most. That, if plaintiff seems totally unwilling to resolve this dispute, then there's, again, you just have to bring that up with the court, and the idea that that's going to, and also to the extent there's a way to show if plaintiff's not being honest with the court, or defendant for that matter is not being honest with the court, if they're not negotiating in good faith, that's something that can typically be brought up in terms of resolution, and making sure if they're making proffers to the court to the contrary, then I think that's when I would bring it up.
Absolutely. And again, we're just about out of time. If anyone has any questions, we'd be happy to answer them right now. The final slide of this presentation includes our glorious pictures, so you can see what we look like while you're talking to us. It also includes our contact information. Please feel free to reach out to us via phone or email if you have any follow-up questions about this, if you want to talk to us about any of these issues. I think hopefully the one thing that came across from this is that these ethical issues can actually be very interesting. They're very dynamic, thought-provoking even in some cases, and we're excited and would love to talk to you more about this topic.
Totally agree, Mary. Thanks so much.
And thank you all for joining us today. We appreciate everyone joining us in the middle of this public health emergency, and we hope that you're all staying safe, that you're doing your best to stay sane, and please wash your hands. So, Liz, anything to add?
No, I just put up this slide here with their upcoming webinars. So if you're not tired of all the webinars, these are some really great substance and content that we're putting forward. So please feel free to join us. I know I'll be definitely listening to at least one, if not both of them.
And also, please keep in mind there's another webinar from the Advertising Law Group this afternoon at 2 p.m. regarding the current state of some really important cases weaving their way up to the Supreme Court regarding the FTC's ability to pursue defendants and gain certain types of monetary relief when they're proceeding in federal court. So thank you all again. I hope you all have a great day.
Thank you.